Hi, I'm Noah Weisberg.
And I'm Garrett Horrocks.
Welcome to Holland Estates. You are listening to episode number 549. How are you, Garrett?
Good, thanks, Noah. How are you?
I'm doing well, thanks. So, we've got a really interesting paper that you and I are going to discuss today. It can be found in the Canadian Bar Review, volume number 45. And this paper deals with the 1870 decision in Banks and Goodfellow and the time to update the test for testamentary capacity. So just summarily, Garrett, basically this paper discusses the historic test for capacity as discussed in Banks and Goodfellow. It provides a alternative medical legal approach to assessing testamentary capacity. Stu and I are going to discuss those two aspects of the paper, and then we're going to close with, when it comes to drafting wills, what solicitors should consider in assessing capacity.
Yep.
So the paper is by Kenneth Schulman, Susan Himmel, Ian Hall, Carmel Pesa, Sean Amadeo, and Courtney Barnes. So a great mix of doctors, lawyers, judges, and other professionals. So a really nice, well-rounded background of authors. So why don't we start off briefly, Garrett, by discussing Banks and Goodfellow and the tests that arose in the Old English decision.
So, as many of our viewers probably know, Banks and Goodfellow is the seminal test the seminal case for setting up the test for testamentary capacity. The case is now about 135 years old, 138 years old. It's 2018. Wow.
Yeah.
And we're still relying on it today. And this paper does a good job of explaining how we can go about maybe modernizing that test. So,
I guess just briefly, the facts in Banks and Goodfellow are such that the testator decided to make a very simple will, which essentially left everything to his niece. And I believe the issue was not whether the testator had the capacity to make a will, but the concern was that he was a paranoid schizophrenic, which tied into his capacity to make a will. So what was the actual test that arose in Banks and Goodfellow?
So the Court of Queen's Bench set out a four-part test to test for testamentary capacity. So the first criterion established by the court is that the testator must understand the nature of the testamentary act or disposition and its effects. The testator must understand the extent of the property of which he or she is disposing. He or she must be able to comprehend and appreciate the claims to which the testator ought to give effect. And finally, there must be no uncertainty as to whether there was a disorder of the mind that was poisoning his affections, as the court said.
Yeah, so interestingly, the court found that although Banks was in a lunatic asylum, he nonetheless carefully managed his affairs and was deemed to be capable to execute his will. So that's the traditional approach, and this is the test that we've been applying in today's society, notwithstanding its 1800s when it was first created. So I don't know if it's worthwhile to get into the old test because our viewers can read that in the paper. But why don't we get into some of the concerns that have been posed by the authors in this paper as to why a new test should be considered.
So it may come as no surprise that estates back in the 1870s, when Banks was first, when the Banks decision first came out, estates back then were far simpler. Most people had very little property, or they may have had some shares in some small public corporations, and generally very little in excess of that. Nowadays, as we see in our practice on a regular basis, estates have become increasingly complex. Testators have complex corporate shareholdings, complex share portfolios, real estate holdings, et cetera, et cetera. So it becomes a little bit more difficult to assess, in particular, the second criteria as to whether the testator has appreciation of appreciation of the value and nature of his or her assets, essentially.
Right, and I think that's a great point. Today assets are much more sophisticated. The other, I think, development that we see is that we know a lot more about capacity.
Mhm.
And what this paper suggests is that uh, capacity is specific to time, situation, person,
Mhm.
and the task.
Mhm.
And I think somewhat that speaks to your comment regarding the sophistication of and complexity of assets,
Mhm.
but it also speaks to the idea that people can go in and out of capacity depending on how complex the task is. Can also affect capacity. So you may need a lower level of capacity to execute a simpler will than you would a more complex will.
Right, and I think that one of the main takeaways that I got from this paper is that we have to look at the context under which a will is executed. You have to look at the relationships between the testator and the beneficiaries. You have to look at the nature of the assets. So it's not necessarily going to be or shouldn't necessarily be the same analysis as between every case, every will, every testamentary disposition. Every fact scenario, every sort of situation is going to be necessarily dependent on context. And I think that's one thing that this paper tries to stress is that we've modernized certain developments medically and in terms of how assets may be held. So maybe it's time to revisit that the test for capacity, sort of following up on that.
Yeah, and then the authors conclude that each will is unique, and each person is unique, and that's got to be taken into account. So, what is the new proposed definition according to the authors of this paper?
So they add a little bit of nuance into the test from banks. So they propose a 5-step test instead of a 4-step test. They propose that a testator must be capable of understanding the act and making a will and its effects, which is identical to the first criterion in banks.
Yeah.
The second step is that a testator must be capable of understanding the nature and extent of the property relevant to the disposition. So that's a little bit more the contextualized analysis as compared to the analysis to the criterion in banks. Again, keep in mind the nature of the assets, the family relationships, and between the testator and beneficiaries, etc. So it's a little bit more nuanced there. Third step is that the testator must be capable of evaluating the claims of those who might be expected to benefit from his estate and able to demonstrate an appreciation of the nature of any significant conflict. So again, that's a little bit more nuance in respect of the third criterion in banks. Again, you're just looking at contextualizing the kind of the circumstances under which the will was drafted, the relationships between the testator and the beneficiaries, the nature of the assets, etc.
Mm-hmm.
The fourth step is that the testator must be capable of communicating a clear, consistent rationale for the distribution of the property. And that's interesting. So in this paper, the authors sort of suggest that we look back at prior wills, for example, to see if there's a kind of a consistent estate plan that the testator is following through with or maybe making minor amendments to, or whether there's a significant change in his estate plan that might call into question his capacity or might engender like a greater analysis into the circumstances.
Right, and if they can explain why there has been a change, if there is going to be one in the estate plan.
Right. And the final step is that the testator must be free of a mental disorder, including delusions, that influences the distribution of the estate. So again, it's a little bit more nuanced in that, as Noah said earlier, capacity can change, capacity can fluctuate on a fairly quick basis. So it's important to look at the context and look at the specific circumstances under which this specific will is being executed.
Yeah, and I think that's a really good point. The authors note that it's not a complete overhaul of the bank's assessment because they still want to have some sort of flexibility. And that's where I think the bank was extremely helpful, as it did allow for flexibility. And I think this new definition still allows for that. So just before we finish off, one thing that doesn't change, whether you're applying the Banks and Goodfellow test for capacity or this new definition proposed in the papers, is what should solicitors do. And certainly solicitors should always have discussions with their clients to make sure they're capable. One thing that we see more and more now is if there is any concern that the testator may be incapable, or if they believe that there could be some sort of litigation or will challenge down the road, it may be worthwhile to retain a capacity assessor to have the testator assessed at the time. The case law suggests that the two key points when making a will are the day that instructions were given to the drafting solicitor and the day of execution. So solicitors, again, whether they're no matter which test of capacity they want to apply, should think about if a client ever reaches that gray zone, or if there's early signs of potential litigation down the road, to seek out the opinion of a capacity assessor to undergo that really microscopic analysis with the hope that a will challenge can be avoided at a later date.
Right, and I'd just maybe throw in that we'd always recommend that a solicitor kind of explore, again, the context under which the will is being drafted. So explore the nature of the relationship between the testator and the intended beneficiaries, just to get an idea as to why the testator may be setting up the estate plan as he is, because again, that may avoid some problems down the road.
Yeah, great. Well, I think that concludes our podcast. Until next time, we want to thank you for listening. I am Noah Weisberg.
And I'm Garrett Horrocks.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog. Thank you, Garrett.
Thank you.